The United States Supreme Court wrapped up its business at the beginning of July. A lot of attention is given to what the justices decide at the end of the case's journey to the court. But the fact is, there are rich, complex, and nuanced stories surrounding every stage of any Supreme Court decision. Who is involved, how the decision is framed and articulated, and even when a ruling is issued or not issued can sometimes reflect broader political and judicial realities. While not all votes fell along partisan or ideological lines this term, there's no denying that the conservative justices made their mark on modern jurisprudence. When it comes to cases with drug policy implications, the who, how, and when of this session may provide some insights as to whether the majority's current judicial philosophy will aid or hinder reform-minded efforts going forward.
From the Drug Enforcement and Policy Center at The Ohio State University, this is Drugs on the Docket. Each episode will tell the story of how U.S. court decisions impact drug law and policy and continue to shape the war on drugs. I'm your host, Hannah Miller.
Today, we are covering the 2023 term decisions of the United States Supreme Court.
If you like what you hear in today's episode, visit go.osu.edu/drugs on the docket to follow the series.
Before we begin, I just want to recognize that there are other podcasts out there with way more listeners that cover the Supreme Court of the United States and its decisions. We're not those people. This is not that podcast. And while Doug and our guests, who Doug will introduce in a second, are lawyers, they're not necessarily con law experts, but you don't have to be con law experts to talk about the Supreme Court or ruminate on the potential externalities, both positive and negative, of Supreme Court decisions. So without further ado, Doug, will you do the honor of introducing today's guest?
It is absolutely my pleasure, Hannah, to introduce Chris Geidner. For nearly 2 decades, Chris has been one of the nation's leading reporters in the country covering the Supreme Court and lower courts. He's given particular emphasis in his time reporting on the court to LGBTQ issues, as well as criminal justice issues, which we're going to focus on a little bit more here today. I do think of Chris actually as a con law expert, but also as an attorney, an award-winning journalist, and the creator of Law Dork. And I want to do a plug for www.lawdork.com, where you can find copious work by Chris. He's a proud graduate of our own Moritz College of Law at the Ohio State University, and actually was a student of mine. And I remember meeting Chris when he was coming in as a 1L. And so that, I guess, shows how both old I am and how old he is as well, because that was quite some time ago. But we've been fast friends since then. And among other things, he highlighted for me the virtues of blogging as a medium for covering law and legal topics really effectively. And I think of Chris first and foremost when I think about incredibly capable and thoughtful lawyers who are also journalists and bring both of those talents to bear in explaining a range of complicated legal topics. And so I am so proud and pleased and grateful that Chris is joining us here today to talk about this past Supreme Court term and particularly issues related to criminal justice and drug policy as they intersect with some broader themes the court has been addressing and what has obviously been, probably everybody knows, a quite notable, really historic term.
Yeah, I mean, just thanks for having me.
We're taping this, roughly 3 weeks after the court wrapped up, and it's probably still too early to have historical perspective, but I sense you have a lot of perspectives on what the court's up to and what it's been doing. And so I'd love to hear just some of those big overview points about the sort of court and the court's work this past term before we drill into some of the criminal justice cases, especially as they relate to drug enforcement.
I have been watching the court closely as a person who has at least a modicum of legal training, and then as a lawyer, since all of the justices, with the exception of Justice Thomas, were through their confirmations. So 8 of the 9 justices, I was watching their confirmation hearings as a lawyer or a person who had taken the bar exam at least.
Considering you've been following the majority of these justices since they started on the bench, you've seen different iterations of the Supreme Court bench. And so how different is this bench?
The biggest change is this is a far more conservative Court. That's the one that everybody's talked about. The other change is the fact that there were no changes to the court from when Justice Breyer took the bench to when Justice O'Connor announced that she was retiring. It was, I think, 12 years, 13 years, where you had the same 9 justices hearing every case, hearing every application, hearing every argument together, literally sitting in the same order next to the same people. And that makes a big difference. Now, we've basically had a change every year or two since Justice Scalia died in 2016. I always talk about the Supreme Court is an ocean liner that has 9 captains, and until 5 of them agree on something, the ship just lists. And if you have the same 9 captains for 13 years, everybody sort of knows, like, oh, when it's raining, we turn to this captain and ask him or her what to do. When there's ice, we turn to this captain and ask what their expertise tells us. But when you're changing up captains every year or two, you throw the issue into the middle of the ship and say, okay, what are we doing this time? And sometimes you get a surprising vote. And I think that that's sort of a little bit what we're in, with the caveat that the entire ship has moved strongly to the right.
When I was going to law school, to be a conservative jurist meant you didn't have the courts do too much, and the courts ought not be striking down the things that the democratically elected branches or even the agencies were doing, because that's not the role of a court. The court should be restrained. My sense is this current court ought not be described as restrained, and so that the conservatism of its members steering the ocean liner, as you described, has a different valence. I wonder if you can speak to that a little bit, describe that in the context of some of the work that they did this term.
There's 2 big lessons from this term that I've written about, I've talked about. There are a lot of decisions of the court pulling back power to itself from the other branches, from states, from individuals, by more aggressively policing standing. That is the court taking power for itself. The second area, I think there's an effort, whether intentional or accidental, this term, to sort of create a contingency. And the court has sort of set forth 2 possible paths, depending on what happens in the election. There's a more obedient path if there's a Trump victory, and a more aggressive policing of the administration policy if there's a second Democratic victory. One of the most explicit examples of that was with the abortion emergency care case, the EMTALA case out of Idaho. The Emergency Medical Treatment and Active Labor Act is a federal law that provides basically some guaranteed protections for all people in emergency care nationwide. It was initially primarily thought of as a anti-patient dumping law that prevented emergency rooms from dumping patients because they couldn't pay. The law wasn't really relevant for abortion care when you had Roe versus Wade, when you had Casey, because emergency care would include those protections. But once you got rid of Roe and Casey, you had this issue in states that had extreme abortion bans, where potentially even where under their state's abortion law, emergency care, if it required abortions, might be illegal. And the Biden administration, immediately after Dobbs, reiterated a policy that it had noted before Dobbs that said that to the extent that EMTALA conflicts with a state law, federal law preempts. After Dobbs comes down, Texas sues the Biden administration and says they don't conflict. There's no conflict between these 2 laws because EMTALA wasn't ever intended to provide abortion restrictions. Whereas in Idaho, the Biden administration sued and said, EMTALA does conflict with your near total abortion ban and federal law preempts. And so you had these sort of mirror lawsuits going up in Texas, where you had it before the Fifth Circuit, very conservative court, and Texas got an injunction at the district court saying the federal government in Texas couldn't enforce EMTALA to preempt Texas law. It was affirmed by the Fifth Circuit early January. There was an injunction issued in Idaho that did say that Idaho's abortion ban was limited to the extent it conflicted with EMTALA. Idaho was appealing that to the Ninth Circuit, but they then asked for cert before judgment and asked to skip over the Ninth Circuit. And after the Fifth Circuit had issued a ruling saying that the injunction against EMTALA applied in Texas, the Supreme Court said, no, Ninth Circuit, we're not going to let you hear your appeal. We're going to hear that. But then after they heard the case, they decided, no, there were too many issues still confusing about this. We shouldn't have granted cert before judgment. So it's now back at the Ninth Circuit. So they had grabbed the case early. And then after hearing arguments, they were like, yeah, they dismissed the case as improvidently granted, digged it, which means literally, oh, we shouldn't have taken this. So it is the very rare case, and I'd need a historian to tell me when the last time is that the court granted cert before judgment in a case, which is aggressively taking a case early and then digged it, saying we shouldn't have taken it.
What does the Fifth Circuit decision, how does that impact the Ninth Circuit?
Doesn't. It is the primary example of the court putting off to see what happens in a future administration, because now the Ninth Circuit will hear the appeal. They'll make their decision, assuming that they disagree with the Fifth Circuit. And you will then have a circuit split, which is then the normal circumstance in which the Supreme Court can hear an appeal. At the same time, however, we're going to have an election and the administration might change. And if the administration changes to a second Trump administration or other Republican administration, the odds are their view of EMTALA would change. And so you then would not have any potential conflict between EMTALA and either the Texas or Idaho cases, Idaho abortion bans. And so the case would just go away at that point. But if there is another Democratic administration come January, then the Supreme Court basically would be forced to actually deal with the issues that it didn't that those middle three justices in a concurring opinion, Justice Barrett wrote it, but she was joined by Chief Justice Roberts and Justice Kavanaugh, that they sort of said, this raises some questions and we don't really know enough facts yet to decide. We shouldn't have granted cert in the first place. They would then basically have to make a decision on the case.
Why wouldn't they just go ahead and make a decision? If the political intent was to ensure that Idaho's law remained.
If you want a political lens on top of it, the political intent was not to have an anti-abortion decision this term, because that would mean that a Democrat would win.
The really hot label here is federalism, meaning what's the relationship between the federal government and state governments as they try to regulate, whether it's access to abortion and healthcare, or healthcare and drugs, or psychological help, you name it. Two of the things that I think are fundamental to the court's work that in a very broad way impact drug policy that the abortion cases are a variation on is who gets to decide things, right? And so the Dobbs decision, he sort of didn't say abortion's legal or illegal anywhere. They said, we as the Supreme Court don't think this is a matter of constitutional jurisprudence. And it's up to the states to decide these issues on their own. Now that these are state issues, how they regulate or restrict abortion access, what are the terms of that are permissible? And so the EMTALA case is an example of where there's general federal law that provides for certain kind of health care. Does a restriction on abortion interact with that at the state level? There are other cases where this is coming up for drug policy. So we can see in lots of settings, there are general federal prohibitions. We've certainly seen in the marijuana space where states are going their own way. There hasn't been an aggressive effort to say, hey, state, you can't legalize marijuana while we have it illegal, right? If the federal government reschedules marijuana and makes it Schedule 3 so that it's now medically available in some respects or with some federal imprimatur, are states still going to be able to prohibit it completely if they want to? What about when an agency has a special rule, particularly in the context of the abortion pill, of authorizing a certain kind of drug? Can states prohibit access to that drug in a variety of ways, or even is the way that drug is being authorized subject to dispute? I think it's quite likely within the next 5 years or so, there will be FDA approval for traditionally illegal psychedelic drugs to be used in probably mental health care of some sort or another. And I think we're going to end up seeing a variation of the same debate where there'll be people who are opposed to that kind of treatment who will say, no, that's wrong, FDA. You shouldn't be approving a psychedelic drug for those kinds of uses. Or maybe, again, you have a state that wants to not let its citizens access that drug on a variety of different grounds. And is it fair to say that there are certainly a number, perhaps a majority of the current justices who want the ship heading back in time because they're originalist by inclination and they think the way in which we should interpret the Constitution is with particular focus on founding era or maybe Civil War era originalist concerns? And yet I certainly see some tension brewing even among the conservative justices there. And I wonder if you have the same take.
I think originalism is on choppier waters than it's been on in a long time. I think that Justice Kagan is doing an incredible job on the court of really challenging some of the absurd results of originalism and also expanding the scope of what we mean by originalism. What we saw in Rahimi, it was like my originalism picture book day. It was like bring your originalism to class day.
It's just such a funny idea to imagine each of the justices bringing in their little coloring book and be like, okay, decide where the lines are when you're coloring in the originalist page.
But outside of that, I think you saw, again, some more interesting writing from Justice Barrett about how she is sort of struggling with this. You saw writing from the left on how they were viewing this. Justice Sotomayor really, really diving in and explaining how Bruin was wrong and what it had done. And then, as we saw a lot this term, you saw Justice Jackson being like, I was not a part of the disaster you all have laid out. And this is basically the Jackson refrain. Like, I get that a lot has gone wrong. And sometimes that's over the past 5 years, the past 10 years, the past 20 years, the past 100 years, depending on the case. And I think that she has, in some ways, taken a page out of Justice Thomas's playbook and said, I do not mind being the solo dissent. I am laying out a vision for what I think the court should be doing, how I think America should be organized, how I think our democracy should be organized. And I'm young. I'm going to be here.
Speaking of Justice Jackson, she used to serve on the United States Sentencing Commission, which is one of the many agencies likely wondering how the case Loper-Bright might impact the work that they do going forward. So I'm really curious to hear your thoughts on the court's decision to eliminate Chevron deference. Why was Chevron deference so important before?
Chevron deference, in some ways, was a really simple thing. It was deciding who we look to initially for making decisions. You have laws. And if laws are passed and if they are clear, we go to the law. And that's the beginning, middle, and end. But and the way that Justice Kagan describes it is that there are lots of gaps because laws can't cover everything. And sometimes those gaps are intentional, sometimes they're accidental, sometimes they're a function of the passage of time and something changing that wasn't able to be considered. And the question is, when that happens, who decides what goes forward? And what Chevron said is that if there is that ambiguity and an agency that is charged with interpreting that law has a reasonable interpretation of the law, we're going to defer to that. And so you already had 3 levels of check. You had the statute had to be ambiguous, the agency had to be charged with interpreting that law, and the agency's interpretation had to be reasonable. What the court said in getting rid of Chevron is no. We're not going to use that rule anymore. And that's sort of wild, because it is saying for all laws in all places affecting all matters, we are not going to defer to reasonable agency interpretations.
Yeah. On this podcast, sometimes I really have to reach for a good parallel that makes constitutional jurisprudence like more accessible to those of us who aren't legal scholars who might be listening to this podcast. But in this case, Justice Jackson served it to me on a silver platter in her dissent. She wrote, "As the government, aka the conservative majority, sees it, every statutory cross-reference can have different temporal branches depending on context." And then she's like, "We have never viewed statutory cross-references as a gateway to the multiverse." I mean, there's pretty strong evidence here that Jackson is a Marvel fan, because she's basically comparing the conservative justices to the time variance authority. So if the conservative majority views the existence of multiple temporal branches unfavorably, gutting Chevron deference is basically like pruning these branches in order to maintain like a sacred timeline.
I think the legal fiction that Chief Justice Roberts employed in order to reach that is really based on one sentence in his opinion, in which he said that there has to be a single best reading of any statute.
Right. The sacred timeline. But jokes aside, Doug, in your opinion, how could the court's decision to gut Chevron deference complicate or hinder developing drug policy?
We have ongoing right now the agency consideration of where marijuana should be placed in the Controlled Substances Act. And I'll be the first one to say, because I've read it multiple times, the description in the statute in the Controlled Substances Act as to what schedule a drug goes in, it's not ambiguous in any sort of sense of like, I don't know what the words mean. It's just the evidence is textured. Right. So the high potential for abuse, or the one issue that's particularly gotten attention these days, is accepted medical use. That's the language of the statute, whether or not a drug has accepted medical use. And the problem for the advocates for marijuana reform for a long time was the DEA, an agency, interpreted that to mean the FDA, another agency, had to actually approve a drug for medical use for it to have accepted medical use. Now, HHS, Health and Human Services, has adopted a different view of accepted medical use, where they say, hey, 30 some odd states have medical marijuana programs. That seems pretty darn accepted to me. And so that seems like accepted medical use. And so we're going to use that as a foundation for rescheduling. I don't know how Chevron fits into this picture. I do know whatever gets done, and I think the expectation is we'll see rescheduling sometime this year, there's going to be a court challenge. There'll be some people who say, oh, the agency got it wrong. The best reading of the statute is marijuana should still be in Schedule 1. I think there'll be other people who will run into court and say, yeah, the agency got it wrong. The best reading is it shouldn't be scheduled at all.
That's exactly what's happening in the mifepristone case, because there was also a case brought by Democratic states that is Washington versus FDA. They were arguing that the 2021, 2016 mifepristone rules that were established were not relaxed enough, and that the regulations need to be even further relaxed. And so you might have had some conflicting rulings. But to back up now into Chevron, the problem of getting rid of Chevron deference is now you have overworked district court judges who are now going to be expected to become experts on any case that comes before them. Chevron deference, I think, had the capacity to take down the temperature, because you didn't have to, as a judge, agree with the interpretation. Your standard was sort of like, do I think they got it wrong? Like, is there no way that this is the way that it could be interpreted? And if you couldn't say that, you kind of, in most instances, your answer as a judge was, I'm the judge. I don't need to get involved. That's up to the agency to decide. And I think if you are opposed to term limits for state lawmakers, you will be very familiar with this argument, which is when you get rid of expertise that an official can have, special interests take on heightened powers because they can quickly become the experts.
And this is something I've been giving some thought to, how much prisoners, other people impacted by the criminal justice system at the federal level, particularly when we're talking about Chevron deference, have the opportunity to be in court, because they're in court anyway, and can challenge whether it's Bureau of Prison rules that are limiting the reach of the First Step Act, which is a pretty broad law that ought to give more and more authority to prisoners to earn credit off their sentences, whether it's challenging a variety of Department of Justice rules that are, again, agency rules that I fear, for lack of a better term to use, courts will find other ways to defer to certain agencies that they want to defer to.
Applying an ideological lens, if not a partisan lens to it, it's very easy to imagine what, for example, a Judge Matthew Kaczmarek does with a Trump administration regulation versus what he does with a Biden administration regulation. Even under good faith, Matthew Kaczmarek is going to think that a regulation passed by a Trump administration is reasonable, is the best single interpretation of the statute.
I think it's absolutely right that there's wisdom and caution in an instinct to defer, and yet the overruling of Chevron deference takes that away in that setting. But we actually saw the court in an Eighth Amendment case seem to kind of lean into this idea of deferring, this time to sort of state efforts to deal with homelessness, though, of course, it was to allow the criminalization of certain behaviors connected with homelessness. Is this just the stakes in politics are different, or is it, they'll defer, but they want to defer on their terms in certain cases? Justice Gorsuch wrote the opinion for what was the sort of traditional 6-3 ideological split. I certainly was intrigued to see, it seemed like a kinder and gentler rejection of the claim.
I do not find it to be kind or gentle. I do not think that the Grants Pass decision was kind or gentle. Justice Gorsuch all but said that he would reverse Robinson if that came to him.
I want to pause and do a little history. The Robinson case was a famous and also notorious case from the 50s and 60s. California had passed a law that literally said, it shall be a crime to be addicted to narcotics, period, stop. And so that meant even if you were working on your addiction, even if you were addicted somewhere else, even if you never used drugs and just showed up somewhere and say, well, I feel I'm addicted to narcotics, you're a criminal. And I think not surprisingly, the court struck that down. What was surprising at the time was That case wasn't argued as an Eighth Amendment case, a cruel and unusual punishments clause case. It was really argued more as a due process case, though I think it also is an Eighth Amendment problem to try to criminalize any status. And so I don't think you should throw dirt on they use the Eighth Amendment if you want to say, as this is where I got to the kindler, gentler, there was at least a hint of the idea that if this came up again, where truly somebody was trying to criminalize status, maybe we would say that's a due process problem.
Yes, there's a possibility that we could do that. In her dissent, Justice Sotomayor tried to say that there are other avenues to challenge this, but that is cold comfort when you look at the actual statute that they upheld. What it said is that camping was a crime, but then how they defined camping included any covering. And so, yes, you could sleep outside without camping, without any blanket. But if you used any covering, that was violating the no camping law.
It's worth noting here, and Justice Gorsuch leaned into it, that Governor Gavin Newsom of California was part of an amicus brief saying, no, you've got to allow us to have these criminal laws to deal with homelessness problems.
I mean, the ironic thing about that is that in any real sense, they were basically admitting that these laws are targeting homelessness because they were saying we need these tools to fight homelessness. But then they were saying, no, this isn't a law that targets status based on homelessness. And it is just criminalizing these actions. And the distinction was that they said that this law in Grants Pass wasn't like that Robinson law saying being homeless is a crime.
There's this often drug or alcohol driven parade of horribles that often lead to saying, well, we can't restrict criminal law too much. Oh, if you can't criminalize being addicted to alcohol, then I guess you can't criminalize drunk driving because it's because I'm addicted to alcohol that I get behind the wheel. Oh, if you can't criminalize being addicted to heroin, then I guess you can't criminalize breaking into a drugstore to get opioids. Oh my God, it's so scary. We can't have it function that way. And everybody recognizes, I think rightly so, no, you can criminalize conduct. The problem is when you criminalize conduct that becomes so connected to the status, then you really get at the hard spot here. And I think the dissenters in Grants Pass were kind of emphasizing that point. And it remains to be seen if there's going to be any opportunity to use the Eighth Amendment for any other limits in these kinds of settings.
So we've covered Loper Bright, the anticlimactic EMTALA case out of Idaho, as well as Grants Pass. Should we then just go ahead and move on to more drug-specific cases? We actually recorded an episode about one of them, Pulsifer, but the Supreme Court had not reached a decision, I don't think, when we were discussing it. I think at the time of the recording, they had just granted cert, but I know there are a few others, Doug, if you care to summarize any of them.
I'm a big Pulsifer fan just because it obsesses over the First Step Act. There was a Armed Career Criminal Act case involving drug offense predicates called Brown. There was a case called Diaz about expert evidence in drug cases. There was a civil forfeiture case, Cully v. Marshall, which ended up being kind of like a crappy little procedural matter.
Basically, how quickly you need a hearing, whether you need a mini hearing before the hearing.
Right. And I think in all the cases that I rattled off there was at least one traditionally conservative justice with the dissent and one traditionally liberal justice with the majority. And if I get the facts out right, somebody had lent their car to somebody, I think the kid.
There's an innocent owner defense.
And that kid goes and drives around with drugs in the car. They get picked up. The state not only arrests the person driving around, but then they civilly forfeit, which means they don't have to go into criminal court. They can just use a civil procedure to grab the car, essentially, because it's involved with a drug offense. And now it's about how quickly can the real owner, the innocent owner, get their car back.
Yeah, there are stories in the brief and even the one case that it ends up being like a year before you get your car back, which obviously, depending on who you are, that could mean you've lost your job. And the court sort of dodged the issue in a way by sort of like pinning the case down to they're asking for a hearing before a hearing. And we're going to like say that we're just deciding it on this very specific issue that you're asking us to sort of constitutionalize subpart of a process, and that's not traditionally what we do.
I certainly read Justice Gorsuch and Thomas to be kind of at least signaling that they were open to the idea of doing something constitutionally about civil forfeiture.
I mean, this is something that Thomas has long done, where he basically says, bring me this case. I would like to decide it. And in that sense, you do have 5 justices who are very willing to hear cases brought by the Institute for Justice and Pacific Legal Foundation and ACLU. They can team up and will strike down some aspects of civil asset forfeiture. They haven't granted any cases for next term, but I will say civil asset forfeiture cases have been making their way to the court pretty regularly. So I have no doubt that they will have an opportunity, if they want, to grant cert in another one of those cases again soon.
I do think criminal justice reform arguments have at least the potential to develop some stranger bedfellows. And among the things that I think Drugs on the Docket is trying to help people do is, well, are these big picture stories about all these rights and liberties, or are these drug stories? And of course, the answer is often it's both, right?
It's certainly become more and more apparent through our work at the center and our collaboration on this podcast with people like Chris and like David Posner that we need to be following Supreme Court trends, because even if it doesn't seem drug related, or even if, as David pointed out in his book, there has historically been drug exceptionalism in constitutional jurisprudence, like many of the United States Supreme Court decisions are going to impact drug policy.
We are incredibly grateful, Chris, that you helped us navigate, it's kind of the lighthouse perspective on the ocean liner working its way through these waters. And I know I learned a lot along the way. And I'm, again, so grateful for your perspective and a chance just to hang out and talk with you about these issues. It's been terrific.
The lesson is twofold. Just keep paying attention, subscribe to Law Dork, and also to realize that the reality that even the justices are sort of acknowledging how much hangs in the balance of this election.
Drugs on the Docket is a production of the Moritz College of Law, Drug Enforcement and Policy Center. This episode is produced by me, Hannah Miller, and Holly Griffin. Doug Berman is our editorial advisor. The music is composed by Joe DeWitt.